DM. Present in the virtual courtroom, we have both parties as well as Ms. Canfield for the plaintiff, Mr. Carson. This is the continuation of the divorce trial in this matter. And when we adjourned last time, Ms. Carson was on the stand, and I believe we were in the middle of cross-examination. Is that your recollection, Ms. Canfield?
Yes, I think that is accurate. You are
All
correct.
right. Okay. Ms. Carson, you are still under oath.
Thank you. Ms. Carson, when we left last, we were talking about the unfortunate injury that happened to your daughter. Do you recall that, ma'am?
Yeah.
Okay. So you had indicated to me, and just to refresh the record, that there had been some type of a dead bird or things when you arrived home from your walk.
Yeah,
Uh,
there's dead baby birds.
okay. And so you went to clean those up and left your daughter in her stroller.
Yeah, I was trying to move it out of the way so I could get into the house.
All right. And then she was belted in somewhat, but got herself out of that.
Yes.
And then she stood up in the stroller and the whole thing tipped. Is that correct?
Yes.
All right. You took her for emergency care and then a couple days later notified Mr. Carson. Is that accurate?
I can't exactly remember the exact day. So,
Okay.
yeah.
But it was not immediately when she was receiving treatment. Is that fair that you
Yeah.
contacted him? Okay. Can you describe for the court what type of treatment your daughter had to go through for that?
Oh, they had to use they had to sedate her so they can check her teeth, and then he said that she was fine, but I said that I wanted an x-ray. So he wanted to release me without an x-ray, but I requested an x-ray, and then he did an x-ray, and then the x-ray revealed that her jaw was broke. I think her bottom bones were a
Okay.
little bit fractured. She had a jaw fracture. So then they sent us to the Children's Hospital, Children Davos or Helen Davos.
Okay.
And then we were there for, I don't remember exactly. I would say maybe at least we were there for one night.
And did they have to do any wiring or any surgery for your daughter that you recall?
No.
I know she's little, but were you able to tell whether she was in pain or not?
Like, yeah, she was definitely in pain when she fell.
Can you describe how long it took for that injury to heal, if you know?
Um, yes, it took. I remember we were she was on a liquid diet for I can't. I don't have all the papers in front of me, so I can't remember every exact detail, but I believe she was on a liquid, and I could be wrong, but 6 weeks.
Okay.
It was a while that she was on a liquid diet.
During that time, Miss Carson, did your daughter lose any weight?
No, she actually gained weight from the liquid diet.
When was her last physical or well child exam?
It was not that long ago. I would say you're asking me very specific questions, so I can't tell you the exact date, but it really wasn't that long ago. It was
Well, can you give me a month or a week?
uh, can I grab my phone and then I could tell you the date that way? Because I don't remember the exact day.
Let me ask you, Miss Carson, would looking at the calendar in your phone help to refresh your recollection, ma'am?
Yeah.
Then certainly, Your Honor, may she step away just to get that
Yes.
through?
Yeah.
Thank you.
Yeah.
You'll have to excuse me, Your Honor. I'm battling a really bad upper respiratory cold.
It's going around.
Well, and with asthma, it doesn't go so well.
No. Sorry. If you need a break, please let me know.
Thank you.
So she had an appointment February 1st.
All right.
So she's up to date on all of her everything.
All right. Thank you. And to your knowledge, Ms. Carson, did that appointment go okay? She's up to date on her immunizations, but is she also progressing well in her development?
Yeah, all of a sudden she's been talking a lot more ever since she turned 2. She's been saying words, and I've seen a huge turnaround
Okay.
development. She turned 2 January 28th.
All right. And let me ask you, do you allow Mr. Carson to have phone or video contact with your daughter when he's not able to visit in the state?
Of course.
How often would you say they have contact?
He calls me about every couple days.
Does your daughter seem happy to hear from her father?
Yes.
Do they seem to be bonded and have a good relationship to the best of what you can observe?
Yeah, she definitely has a good relationship with him, yes.
Now, we talked a little bit about where you were residing with your sister and that your sister had been paying you rent and then she stopped paying. Is that still occurring where she's not paying you anything to live in your home?
No. Yeah, she's not.
Okay. And approximately how much of your savings do you have left to kind of support yourself without working?
Um, about let's say somewhere around 80 to 90,000.
Have you budgeted how long, if, for example, Mr. Carson wasn't paying the mortgage or any of the bills at the home, have you calculated how long you would be able to reside there without having employment?
Reside in this house.
Correct.
Um, I'm obviously going to sell the house so my husband can get his money
All right.
since he
That's what I
needs it.
wanted to ask, Ms. Carson. So is it your intention then that the two of you would engage in the sale of the home where you're currently residing?
Yes.
What are your plans as far as when that house is sold? Where do you intend to go with your daughter?
Probably nearby to him.
And
Somewhere
my
in
understanding
Colorado.
is that my client resides in Colorado Springs, Colorado. Is that accurate?
Yes.
And you also have a great amount of family out there. Is that true?
In Colorado, yes.
And Mr. Carson has family in Colorado as well. Is that accurate?
Yes.
And so you want to sell the house in Michigan and eventually move out to Colorado.
Uh-huh.
Do you have a timetable for when you intend to do so?
Oh, I was gonna wait till after the divorce process.
Okay. So if, for example, Her Honor granted you a divorce today, would you put the house on the market this week?
I I can't tell you exactly when, but I would definitely get on it.
Okay. With respect to legal custody, ma'am, we spoke a lot about what legal custody was pertaining to your daughter's medical appointments, education choices for her, religious choices for her. Do you feel that you could cooperate and work with Mr. Carson to do that?
Work with and cooperate with Miss for religious choices. Yeah, I'm always very cooperative.
Okay. Do you agree with me, though, that there are some medical appointments and, in fact, the emergency regarding your daughter's broken jaw that you didn't contact Mr. Carson about right away?
What was that?
Do you agree with me that there are some medical appointments and the emergency appointment for her broken jaw that you didn't tell my client about right away?
I didn't call him right when she broke her jaw. No, I didn't.
Okay.
I was too
You-
busy attending to an injured infant.
Ms. Carson, do you recall meeting with Dr. Jeffrey Kilishevsky? I think I might be butchering that name.
Yep.
And during that evaluation with Dr. Kilishevsky, did you indicate to him that you had a history of alcohol abuse?
What? No.
Did you indicate that you used to drink?
I've said that I've drank before, yes, but I don't have a history of alcohol abuse.
All right. Did you indicate that you thought you had unhealthy boundaries set with Nicholas's parents?
So I indicate that I had unhealthy boundaries set with his parents. I don't really know how to answer that question. So
All right. Well, let me ask it a different way. You believe that Nicholas's parents were listening in on your phone or somehow tracking you. Is that accurate, ma'am?
we switched phones as soon as we moved to Michigan. So no, not. I mean,
Well, isn't it true that one of the reasons that you switched phones is because you didn't want them on his parents' account and you didn't want your information tracked or available to them?
I really don't think it matters why we switched phones. We both switched phones together. I can't exactly remember all of the reasons why we did it. But I don't think it's like a wrong thing to not want your in-laws paying for your cell phone.
Miss Carson, I'm not saying that it's a wrong thing. I'm saying, was that one of the reasons, yes or no, that you switched
No, I
phones?
didn't want my in-laws paying for my cell phone. So
That's
that's
all
all
I
I
have to
have to
say
say about
about
that.
that.
Isn't it true that there are times that you left your cell phone at home so that you wouldn't be tracked when you were out of the house?
No, that's not true.
You didn't indicate that to Mr. Carson on numerous occasions.
No.
Do you blame Nicholas's parents for causing your separation in your marriage?
That's a very personal question. So I'm not really going to talk about his parents right now.
Your Honor, I would ask the court to direct the witness to answer the question.
Ms. Carson, you have to answer.
Oh, well, then my answer is I'm not sure. I'm not sure how to answer that question.
That's fine,
It's a
ma'am.
very complicated, it's like a very complicated answer. So
Did you tell Dr. Kilishevsky that you felt that Nicholas's parents knew what you were talking about on your phone?
I don't remember how I worded things.
Did you tell Dr. Kilishevsky that his parents tried to buy your daughter from you?
I did imply that his parents wanted a financial relationship with my daughter. They only wanted a financial relationship with my daughter.
Do you think it's unreasonable for grandparents to want to support their grandchild?
I think it's strange that they weren't willing to meet her for the first time at 4 months old without having a bank account set up for her when she's only 4 months old and unable to use it.
Did you tell Dr. Kilishevsky that you were concerned that Nicholas and his parents were operating a child trafficking ring?
I'm not sure how I worded it, but I just, like I said, I feel like they were implying that they only wanted a financial relationship with my daughter because they did not want to come over when I said that they didn't have to have her money available. When I said they didn't have to have her money available, they didn't want to come.
Mhm. Ms. Carson, when you saw Dr. Kilishevsky, do you agree with me that he created a report that went to the court and the parties for review for this case?
Do I agree with you that he filed a report on me?
Correct.
Yes.
And you've received a copy of that report. Is that accurate?
Uh-huh.
All right. Do you agree with me that in that report, the doctor indicated that your answers to the Millen clinical one of the tests, we'll say, it's the multi-taxial inventory test, suggested that you were having very defensive responses?
I don't remember reading that.
Okay. Do you recall that he indicated that you had a tendency to lean towards emotional impulsivity in close relationships?
Yeah, I read that. I did read that.
And do you recall him saying that you would oftentimes do attention-seeking behavior?
I read that he wrote that, yes.
And do you recall that he said that your answers during the interview with him were quite guarded and not necessarily as truthful as they could have been?
I did read that he said that. Yep.
Okay. You agree with me that he's been qualified as an expert by the court, and that's why he was the one that was able to conduct the psychological evaluations, ma'am?
Do I agree with you that what?
That he was qualified by the court as an expert to conduct your evaluation?
I didn't have any problems with him.
Okay. Do you recall seeing that he indicated that you might exhibit some behaviors that would cause difficulty in a co-parenting relationship with my client, Mr. Carson?
I think I did read that, yes.
If the court were to order you to engage in co-parenting counseling or individual therapy, would you be willing to go?
If the court ordered me,
Correct.
well, yes, of course, I'm willing to do whatever the court orders me to do. That's what I've always done.
Do you know that Dr. Kilishevsky recommended mental health counseling focusing on intervention with reality testing?
Yeah, I saw that.
Mhm. Would you engage in that voluntarily?
Would I engage in reality testing if the court did not tell me to?
Correct.
I don't know. I might for my relationship between my daughter's father.
Okay. And if the court ordered you to, would you then engage in the therapy?
Yeah.
Did you recall reading that Dr. Kilishevsky indicated that your paranoid statements were not founded on credible or remarkable evidence or observation?
Mm-hmm.
I'm sorry, is that a yes?
Yeah, I think I read that.
Yes. It's just, for the record, just for your information, it's very difficult for them to transcribe mm-hms and uh-uhs. So if you could say yes or no, that would be most helpful. The transcriptionist would be appreciative, I'm sure. All right. And when you moved to Colorado after able to sell your marital home post-divorce, Miss Carson, would you be willing to engage in 50-50 custody with my client?
If I moved to Colorado,
Correct.
at this point, I don't really think it's in my hands. So, I mean, I don't really understand why what I want matters.
Well, it's always important.
Obviously, I personally want custody of my daughter at all times. She's just 2 years old, and I would like to be around her every day because she's only 2 and she's a baby. But in this world, that's not how it works. So.
Well, do you agree with me that you've been present during some of Mr. Carson's parenting time with your daughter?
I've been present for every time except for when I went to Colorado for Christmas vacation and he took her twice to see his family.
And she came back happy and healthy, is that correct?
I'm not sure. She was acting strange. And she did have a diaper rash for the first time in her life. Nothing like extreme that suggested anything out of the ordinary, but still, I don't know why she had a diaper rash.
Well, she didn't have any bruising or any other injuries, correct?
No,
And she appeared to have enjoyed the time with her dad and his family.
she didn't. She just came back asleep. Can't remember if both times she came back asleep, but the last time I remember she was asleep.
And you had previously testified, Ms. Carson, that you typically are up until midnight and that you wake up at 10 in the morning. Do you still do so?
I don't really have a set sleeping schedule, but yeah, I mean, my sleeping schedule is not ordinary.
And you indicated that you keep your daughter on your schedule that isn't set and consistent.
Not always.
All right. What do you mean by not always? Do you develop a different schedule for her?
Well, sometimes she's asleep and I'm not asleep. Yeah. I don't sleep as much as a toddler does.
Okay. Would you agree with me that it's really healthy for a toddler to have like an earlier evening bedtime and sleep until the morning hours and not be, going to bed at midnight?
Maybe when she's closer to having to have a normal schedule, like preschool and school, I think that it's definitely good to get her used to that, yes. But as of now, she doesn't really, have a reason to go to bed early and wake up early, in my opinion.
Well, when does she take a nap, if she does during the day, if you keep those hours that are similar to yours?
I don't take a nap, but she takes a nap around 5, 4 or 5.
Have you ever tried to put your daughter in a preschool or a daycare facility where she's around other children?
She's only 2 years old, so I mean, I don't think she's old enough for preschool yet, but I take her to parks and libraries at least every other day.
Have you had a chance to talk with any other mothers of toddlers to see what time they put their children down and what time they nap?
I do talk to other mother toddlers. I never ask them what time they put their kids to sleep. No.
Do you think it's unusual for a toddler of age 2 to be napping at what would it be the dinner hour for other families?
If you think that I should start putting my kid to bed, my 2-year-old child to bed at 7 or 6, I can do that. That's fine. I'm not saying I'm against that.
Okay. So do you think that if yourself and Mr. Carson spoke about like a daytime and nighttime routine for your daughter, that the same could be done at both households with your agreement?
Yeah.
Ms. Carson, have there been any other instances where your inattention for a few minutes to your daughter caused her harm or injury?
Inattention.
Correct. Like with when she broke her jaw falling out of the stroller. Are there any other times where she got hurt where you were distracted by something else?
No. And the children's doctor told me that it's not unusual for toddlers to have accidents like that. It doesn't make me a terrible parent.
One moment, please, Ms. Carson. Was there a time in your history where you were under any medical treatment for delusional ideation, ma'am?
No.
Is there any history of mental health concerns in your family?
Mental health concerns. I told you my sister has a neurological disorder of some sort due to a car accident.
What about your parents? Is there any history there?
My parents, not that I'm aware of, no diagnoses.
Would you be willing to allow my client to have your daughter for the Christmas holiday since that's what he and his family celebrate?
My family also celebrates Christmas.
Okay, and what about Easter?
Easter.
Correct.
I don't think they celebrate Easter now.
Okay, what about Ramadan and Eid al-Fitr? Would those be your holidays?
Well, Nick doesn't have those holidays, so
Okay. Do you feel that you and Mr. Carson could work out agreeably the division of holidays for your daughter?
um, I'm sure we can. Yeah.
Have there been any instances in which you have withheld parenting time from my client?
I believe the time that she broke her jaw is the only time that I did, I believe, but I mean, I wouldn't say my memory is super perfect, so.
Okay. Would you think that it would be important for a father to see his child who had been injured?
Well, at that time, she wasn't completely bonded with him. She was still really uncomfortable and screaming anytime because he spent some time away from her before he saw her. So it took a while for her to warm back up to him. And when she had a jaw injury, I didn't want her to do anything that involved like crying and using her jaw too much because that's what the doctor told me to do. So I believe with my memory, I just told him to reschedule. So he didn't like come to my door, and I didn't like refuse him to come here. I just told him that I think it's best that you come when her jaw's just not so freshly wounded.
All right. Did you allow Mr. Carson to participate in choosing your daughter's pediatrician?
Did I allow Mr. Carson to choose my daughter's pediatrician?
No, to help you with that choice.
Um, we were together when we picked out the clinic. So yeah, the first one he didn't want, and we switched because he didn't want her pediatrician to be male.
Okay.
So we switched a couple times until he was okay with the office that we went to.
And do you agree that you would be able to choose and work together to find a pediatrician in Colorado if you move there?
Oh, you're asking me if he can be in charge of who my daughter goes to see?
If the both of you could agree on that decision.
Oh yeah. Mm-hmm.
Do you believe my client is a good father?
Do I believe he's a good father?
Correct.
From what I've seen lately,
And you had indicated that you believe they were bonding well and that she's happy to engage with him during his parenting time.
yes, now she is.
If the two of you were living close together in Colorado Springs, would you be fine with 50-50 parenting time, a week on and a week off for each of you with maybe some video or phone contact when it wasn't your parenting time?
Video or phone contact when it's not my parenting time?
Yes, so for example, let's say it's not your parenting week and you would like to say goodnight to your daughter. You could do so by video or phone.
You're asking me if I'd be okay with that?
Correct.
I don't know. I mean, if that's what I have to do. I'm not really somebody who breaks the law. So, I mean, whatever I legally have to do, I've always done.
I understood, Ms. Carson. Now, with respect to the family that's out in Colorado, is it true then that Mr. Carson and yourself both have extended family that would be a support system for each of you in Colorado?
Yeah, I mean, I do see my family when they have get-togethers sometimes, sure.
Do you agree with me that it's in the best interest of your daughter to have contact with her extended family?
Yes, and I can't promise you that I'll be able to find a living situation in Colorado Springs, but I'll definitely aim for the state of Colorado. Colorado Springs is quite far from both of our families,
Okay.
2 hours away.
Well, it would at least be closer than Michigan, right? If you were both in Colorado.
Yeah.
Yeah. Where do you intend to work if you move to Colorado?
Where do I tend to work? I'm not sure. It just really just depends on, the custody arrangement.
Have you started to look for potential employers in the event that you're selling the home and moving within the next several months?
It doesn't really take that long for a hairstylist to get a job. So, I mean, I haven't set up interviews yet now.
You think you could be employed fairly quickly?
I'm not sure what the job market looks like right now.
Do you agree with me? If you were intending on relocating, as you've stated, it would be a good idea to start looking ahead at potential employment prospects?
Looking for potential employment prospects.
Correct. In other words, it's good to plan ahead.
Yeah, I mean, if I don't have full custody of my daughter, yeah, I'm obviously going to be working when she's not around me. My plan originally was to work from home with a tarot card business until she was at least in school, because I didn't really want her to have, I wanted to be her childcare until she was in school. So this is my first and only child.
Mrs. Carson, do you understand that in the event that there isn't spousal support ordered, that the only thing that you might receive, depending upon the parenting time, would be child support, correct?
Mm-hmm.
And you would probably need to be employed prior to your daughter going to kindergarten. Fair?
If I don't get to see her all the time, well, yes, I will have to. We'll obviously have to do something to keep busy. And working is definitely something I can do, obviously.
All right. Did you previously have a domestic violence charge brought against you, ma'am?
Did I previously have a domestic violence charge? I
Yes.
was 19. I was acquitted for domestic violence.
All right. Was that the 2012 matter in Colorado, ma'am?
Was that a 2012 matter?
Yes.
I don't know the exact date. I just remember that I was around 19 years old.
Have you been violent with Mr. Carson?
Um, no, but violence has happened between the two of us when we drank when we were younger. There has been, I would say, like violent things that happened on both of our ends.
Do you have an anxiety diagnosis, ma'am?
Do I have an anxiety diagnosis?
Correct.
Yes.
Do you currently take any medication or engage in any therapy for the anxiety?
Um, No, I do have medication for emergency panic attacks, though.
And what happens when you have a panic attack?
I just get shaky and forget to breathe.
How often are those occurring?
Oh, not often at all. Just when the thought of losing my daughter does make me panic a little bit. So
What's the medication?
I think any mother would panic at the thought of losing her child. So I don't think that makes me mentally ill.
Miss Carson, what medication do you take for those panic attacks?
It's an antihistamine for allergies.
Do you recall the name of it?
No, I was prescribed it when I was pregnant. So it's not really an antipsychotic or anything.
Where do you keep it stored?
I keep it stored in far away from my daughter on the very top bookshelf.
Is that a built-in bookshelf or a freestanding?
Built in.
Is she climbing yet at her age?
Can't climb the bookshelves now.
Okay. Have you thrown things at Mr. Carson before?
Not at him, no.
Have you thrown things in the vicinity where he is during an argument?
Probably.
What types of things?
I can't really remember, because most of our arguments happened when we were both intoxicated and young, very young. So I would say 12 years ago.
Have you thrown anything since your daughter was born?
No.
I have no further questions right now, Your Honor. Thank you.
All right, thank you. Ms. Carson, if you had an attorney at this time, your attorney would ask you questions to give you the opportunity to respond to some of the questions that Ms. Camfield asked you. So I'm going to give you the opportunity. You don't have to ask yourself questions, but if you'd like to respond or say anything more about some of the questions or answers that you gave Ms. Camfield, now's the time to do that.
Oh, no, I don't have anything to say.
Okay. All right. Ms. Camfield, do you have any further witnesses?
No further proofs for today, Your Honor.
All right.
I
Ms.
would,
Carson,
I guess if I may reserve, or actually, let me just, if I may look for a moment, Your Honor, to see if I want to recall my client for any rebuttal. I don't have any further rebuttal, Your Honor.
all right. Ms. Carson, any witnesses you'd like to call?
No.
Okay. Anything, Ms. Camfield called you as her witness. So I'll ask you again, anything else you would like to say on your own behalf?
Not at the moment. I can't think of anything at the moment, Your Honor.
Okay. All right. And you don't have any witnesses, is that correct?
I don't have any witnesses.
Okay. Ms. Camfield, closing statement.
Thank you, Your Honor. Well, the court is most likely aware that it does appear that there is an established custodial environment in Michigan right now, but it seems from the testimony of both of the parties that Mr. Carson is currently residing in Colorado Springs, Colorado, and Ms. Carson intends to sell the marital home if that's ordered by the court and to move to Colorado so that they can be closer together as co-parents for their daughter. So I think that along with some of the other best interest factors that have been addressed through the testimony, demonstrate that there is a need to move that custodial environment to Colorado, and that it would likely be with the home of both parents once it's established there. So with respect to the testimony, I think that the best interest factors have been addressed well by the parties, as well as Dr. Kilishevsky's reports that were admitted as exhibits 1 and 2 for the people, not the people, excuse me, for plaintiff, and the best interest factors that were considered in the friend of the court custody and parenting time evaluation and recommendations indicate that both parties are capable of giving love, affection, and care to their daughter. My client testified that he knows what she likes to eat and drink, that he plays with her, that he takes her to parks, the children's museum, the zoo, the aquarium, that they go down the swing and the slide when they're at the park, that he watches informational videos on YouTube so that he can learn how to better teach and parent her in an educational manner. He reads with her. She goes to the library. And it's my understanding that, according to Miss Carson, she also takes her to the library to engage in those activities, and that she is increasing in her vocabulary use and her speech. She also has an evaluation scheduled for her to see if there is any concern that she is on the autism spectrum. But according to Ms. Carson, at the last well child that occurred in February, her daughter was progressing with the appropriate inoculations, as well as the appropriate age developmental stages that are being met. There were no concerns that were testified to that were exhibited by their daughter at that evaluation. It also is clear that there is the capacity of the parties to give the children love, affection, and guidance. It said that weighed in favor of actually neither parent, because they were both pretty equitable there as far as their ability to care for their daughter, to bring her up in a nice educational fashion, and to address any religious upbringing that she would have, that they could give her guidance in that and expose her to both mother and father's religion and allow her to choose one for herself when she's old enough to do so. With respect to the capacity and disposition of the parties to provide the child with food, clothing, and medical care, it's been testified to that, well, in Michigan, obviously, with Mr. Carson residing in Colorado, Ms. Carson has taken her to most of her medical appointments, including the emergency that occurred when she fell and broke her jaw. However, my client has testified that he did go to medical appointments before he relocated to Colorado, and that he's willing to do so and to be at those in the future. It's been testified to by both parties that they could agree on who that pediatrician would be and any care and education that they would need for their daughter. There was, with respect to the giving her things, Mr. Carson has said he's paid for the mortgage for the household. He's also been able to supply any clothing or anything that his daughter would need, and that he is capable of doing so going forward, that he is currently employed and is earning, can't remember the salary, but a pretty decent salary per hour, Your Honor. And an area manager at approximately $100,000 a year, with some bonuses that would fluctuate throughout the year at his current position. My concern is with Ms. Carson being voluntarily unemployed and choosing at this point to just rely on savings in order to meet her bills and living requirements. While certainly they seem to be sufficient at this point, there is an indication that they would not be sufficient for long term and in the future. Though she has testified that she would seek employment, she doesn't wish to do so until the child is in school. While one can certainly understand that a parent would like their child to be at home as much as possible, to be raised by the parents, it is also good for the child to be exposed to other children, to learn how to socialize and play together before starting school age. And this child could certainly do so in a preschool setting if Ms. Carson were to be employed. and to find employment, as she indicates she will seek if she doesn't have full custody of her daughter. My client is requesting at this point that although Ms. Carson indicates she could agree with him on joint legal decision, Mr. Carson's testimony was different from that he was never provided all of the medical appointments, that at multiple occasions he was denied the social security information of his daughter, he was denied the insurance information for his daughter. And though Ms. Carson testified she eventually did turn that over, it took multiple requests of Mr. Carson to get that information, and that she would do so if she were ordered by the court to do so. So I'm not getting the sense from her testimony that she's going to be as cooperative as she indicates she would be with legal custody. So my client at this point is asking for sole legal custody regarding his daughter. Certainly, he testified that he is willing to provide updates and information to Ms. Carson, and she would also be able to access those records for the child. But it's my understanding at this point that they are selling the marital home in Michigan. I would ask that the court order that and that the proceeds be divided 50-50 in that regard. My understanding is they've already separated the majority of their personal property. They've already separated their bank accounts. So their current bank accounts are held in individual names. I would ask that those be awarded each to their own. Now, with respect to physical custody, the best interest factors indicate that there has been a satisfactory living environment for the child with the parents when they were still together, with the mother since they have been separated. But again, my client is full-time employed. He's testified about the home that he lives in, that there's a child room set up for his daughter, that she has the appropriate clothing and age-appropriate toys there that she needs, that he has extensive family in the state that could be a support system for both he and Ms. Carson, that she has family there. And so it's my understanding that the satisfactory living environment and permanence of the family unit would be in both Mr. Carson and Ms. Carson's home once she relocates to Colorado. The moral fitness of the parties was not necessarily questioned by the investigator, and I think through the testimony it's been shown that neither of them have any concerns with respect to their love and care for their daughter. Mr. Carson has no concerns with respect to his ability to cooperate and be in a co-parenting relationship with Ms. Carson, but we have seen some hesitancy in Ms. Carson's answers to me, some evasiveness, if you will, to my questions when I had to ask direct yes and no questions. They were not answered until ordered by the court to do so. So there is still some hesitancy there. It seems like she's still very concerned about the fact that his parents want to support the child financially, that they seem to have listened in. Dr. Kilashevsky's report indicates that she has some delusional ideation that is not based upon fact or circumstance that is observable. It appears to be a concern for Dr. Kilashevsky that those delusions and the paranoia that comes from them may suggest some, schizophrenia or paranoid ideation, which would necessarily interfere with the co-parenting relationship, which is another basis for my request for legal custody solely in my client. I think that both would agree that it's important for each of them to have a loving and affectionate relationship with the child. And it was determined by the investigator that they could do so, that they would allow the child to grow up with a bond and affection with both parents, and neither of them would deny that to their daughter. So I think that joint physical custody would be appropriate. At this point, the child is young, but she does have an established relationship with my client, albeit when he comes into the state. But she did go for some extended time with him over the Christmas vacation recently in Colorado, and was able to engage well with him and to engage well with his family, and seemed to really like the exposure to his parents and cousins, things of that nature. So I think that would benefit the child and allow her to bond then with extended family as well once moved to Colorado. I would ask that there be a 50-50 parenting time, that be week on, week off, with each of the parents allowing phone or video communication, perhaps at bedtime, with the child when they are with the other parent. If there is a concern due to the age of the child for the court and having 7 days without physically being with the other parent, I would ask that the court impose either a Tuesday or Wednesday overnight with the other parent in order for that to split up the week so that they do only have about 4 days without seeing their child. So I think that would be sufficient to allow the child to have bonding with both parents on a weekly basis if there were a midweek overnight. But I see no reason at this point, other than the fact he had resided out of state, that Mr. Carson is not capable of caring for his daughter overnight, and those should be implemented as soon as possible. Would ask that the vehicles apparently have also been divided by the parties, and each will keep their own, and any debt that is incurred thereon, and hold the other harmless for that. I don't know that either party has an extensive retirement account.
I believe we placed on the record at the beginning that all those
Yes,
property
yes, we
issues
did.
were resolved at mediation,
did.
so I don't think we need to go over them now.
I agree, Your Honor. So I would
Okay.
just ask that under the best interest factors, it is in the best interest of the child to have sole legal custody with the father so that he can make some of those decisions regarding the medical treatment, dental treatment, and schooling and religion for their child, as mom seems to be hesitant to include him, although she says she will. It needs to be ordered by the court. And that is a concern for us to come back and have a lot of litigiousness with respect to her uncomfortable relationship with his parents, his family, an uncomfortable relationship with him with respect to, she didn't even notify him immediately when his daughter fell and injured herself. I certainly understand getting the child to emergent medical care for that type of an injury. However, there is no reason that while the child's being evaluated, there can't at least be a 30-second text message to dad. Hey, listen, she's hurt. I'll update you later. This is where we are. And that never occurred until a day or two later. So my client wasn't able to be involved in the decision for that emergent medical treatment. And that is a concern, of course. I think if the roles were reversed, Mrs. Carson would have liked to know that her daughter had been injured and was receiving medical treatment sooner than 24 to 48 hours later. My client will do so. Ms. Carson indicates an inability to do so. No, I think that the proofs having demonstrated what they have, Ms. Carson will engage in counseling and therapy. I think that needs to be ordered, co-parenting therapy, as well as maybe a little bit of a further psychological evaluation for Ms. Carson. But I would ask that there be co-parenting counseling ordered in Colorado by a professional as part of the judgment, that the two attend co-parenting counseling and be able to get along with respect to at least the physical custody of the child. I have nothing further. Thank you.
Thank you. Ms. Carson, this is your opportunity to make a closing statement.
Okay, Your Honor, based on the psychiatrist's report, I didn't read anything about schizophrenia. I believe it was something about either it was a paranoid or delusional disorder possibility. In 2019, I was evaluated by a schizophrenia specialist who stated that I don't have schizophrenia. And I think that me and the plaintiff have a great co-parenting relationship now. We've worked on it a lot since our separation was pretty dramatic at first. I would say things didn't go as perfectly smoothly, but throughout the year, I think we've formed a very healthy co-parenting relationship. We talk on the phone every couple days, and we haven't argued once. There has been no problems between the two of us at all for several months. And yeah, her injury happened, you know, we weren't really talking that much at that time, so I didn't think to talk to him right away. I was just in so much shock. So you know, that was like my parenting mistake that I made, but I think that's all. Thank you. Oh, and I was always planning to start working once she was in preschool, and it was always my plan for her to be in preschool, which is, I believe, in 1 year from now, 1 to 2 years from now. And I was always planning on working from home for myself, setting my own hours in the meantime of that. Like, you know, when she's taking a nap, I can do like a tarot session here and there. So it was never my plan to be like unemployed for the next year. I was just going to set my schedule around her schedule.
All right. Ms. Campfield, any rebuttal?
The only thing that I would ask is that during the time that the child is still in Michigan before the family relocates to Colorado, it would be that my client have any additional time that he would like during the time is that he comes to Michigan, that he'd be able to have overnights instead of just daytime visitation with his daughter until the relocation to Colorado. And I do have a concern still. The schizophrenia, I believe, that was testified to was pertaining to Miss Carson's sister. And there is some concern when schizophrenia is in the family, it can be genetic. And so that is my concern here when there are delusional aspects coming forward, according to Dr. Kilashevsky, that perhaps a further evaluation is needed to rule that out. Since that was his main concern, was that those delusional thoughts would interfere with her psychological capacity to parent and to co-parent with him, if those became more prevalent and interfered with that relationship.
All right, thank you. The court finds that the established custodial environment is with Ms. Carson here in Michigan, not only here in Michigan, but with Ms. Carson specifically, due to the very restricted contact that the father has had in this matter. That raises the burden of proof for the plaintiff to clear and convincing evidence in order to change that established custodial environment. The court has heard from Ms. Carson that she does intend to move to Colorado to be near family, since there really isn't any family here in Michigan to provide support to her or the child, but that she does wish to retain sole custody. Evaluating all of the best interest factors as indicated by Ms. Camfield in her summation, the court finds that all of the best interest factors either favor neither party. In other words, both parties are weigh the same. There's no favor, the factor doesn't favor either party, or favor father. Specifically, the factors regarding mental and physical health, mental health in this case, based on the evidence regarding that Mr. Kilashevsky or Dr. Kilashevsky presented the court as the court's expert. It is clear that to the court that Ms. Carson does have, and based on her own testimony, that she does have, she does struggle with mental illness. that it's essentially untreated at this point, that she does need therapy that she's not receiving, that she probably needs medication that she's not taking, and that this could affect her parenting. The court also so that factor weighs in favor of father. Also, the factor regarding a parent encouraging or facilitating a relationship with the other parent. The history of this case and the evidence shows that Ms. Carson has not facilitated that relationship. She has allowed some contact, but it's very restricted. It's at her basically at her choice. It's been supervised with her present for all of the parenting time. So I'll find that that factor weighs in favor of Mr. Carson. None of the parenting statute factors really apply in this case. This child is no longer reliant on breast milk or nursing or actively nursing for as a basis for nutrition. So none of those factors really apply. The inconvenience of the child for transportation for parenting time also does not apply, given Ms. Carson's stated plan to move back to Colorado to be close to her family, as well as for the child to be close to her father. So I will grant the parties joint physical custody in Colorado on a week on, week off schedule, with one midweek overnight with the opposite parent during their parenting time, as well as liberal Zoom or virtual contact, phone contact, at least once a day with the parent whose parenting time it is not. The 50-50 parenting time is to begin April 12th in Colorado, to give Ms. Carson the time to list the home and get the home sold. If it is not sold prior to April 12th, then she still needs to provide the child to Mr. Carson in Colorado if she's not moving at that time. The home is to be listed within 7 days. The proceeds of the sale of the home, the net proceeds, that's after any fees, realtor costs, et cetera, are paid. Those proceeds are to be divided between the parties on a 50-50 basis. Both parties are to participate in co-parenting counseling in Colorado. And Mr. Carson is to receive overnight parenting time anytime he is in Michigan between now and April 12th. And is there anything else that the court needs to address at this time?
I don't recall the court's finding for legal custody.
Oh, I'm sorry, I did not. Apologies. Again, the established custodial environment is with mother, so clear and convincing evidence would be required to change that established custodial environment regarding legal custody as well. I will grant, I believe the best interest factors favor by clear and convincing evidence giving the father sole legal custody. That means in the event of a dispute between the parents, the father gets to decide. And again, I'm weighing that mental health factor very heavily in this matter, and the fact that it's not been treated. I think that could interfere with decisions in the best interest of this child. That does not mean that the court does not expect the father, Mr. Carson, to share information with Ms. Carson. I'm also heavily favoring father under the best interest factor, again, with the one that indicates whether a parent is likely to facilitate a relationship with the other parent. Ms. Carson has shown that she has a history of making decisions without consulting or even informing Mr. Carson of very important decisions such as health-related decisions. So I will grant sole legal custody to father. And again, the court does still expect him to share with Ms. Carson information, and to the extent possible for both parents to be involved in that decision making. It's just if they can't come to a mutual decision, then what Mr. Carson says goes.
Understood, Your Honor. And with respect to the physical parenting time holidays as agreed by the parties or pursuant to Kent County policy?
I'm not hearing that there's a dispute regarding holidays between the
Okay.
parties. I think they can probably work that out. So I think as agreed by the parties is the best way to go at this point.
All right, thank you, Your Honor.
Judge, have we preserved proofs on this case?
Yes, we have. We did. We did. We did at the beginning. So the court will find the proofs are sufficient, and a judgment reflecting the opinion of the court is, and the mediation settlement needs to be submitted to the court within 21 days for my signature, and please do that electronically.
Certainly, Your Honor, thank you. So Mr. and Mrs. Carson, what that means is that I will be drafting for you that judgment of divorce as the court ordered, and I will send it out to both of you for signature and review, okay?
Okay, thank you.
All right.
Thank you.
Best wishes to both of you. We're adjourned.